Good afternoon, everyone. My name is Jeff Smith. We're going to be going over some fair housing laws this afternoon. Thanks for joining in. Give you just some quick housekeeping here real quick. Again, Jeff Smith. I'm one of the shareholders here at Altitude Community Law. Right now, you should see the PowerPoint presentation taking up most of your screen. Should also be a small box on the left-hand side of the screen with the presenter, myself, on the right. On the right side of the menu, you should see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting. If you have audio or video issues during the presentation, please click the No Audio or Video button below the presentation on your screen and follow the instructions. One CMA credit will be automatically generated and emailed to you after the webinar, assuming you attended the entire program. These credits are not transferable. Please email Jessa Ledesma at JLEDESMA@altitude.law or call 303-991-2086 if you have any questions about the webinar or receiving your CMCA certificate. Lastly, there will be a survey that will pop up at the end of the webinar. Please let us know what you think of the webinar. Your thoughts and opinions are important to us. All right, with some housekeeping out of the way, let's dive into this. There's a fair amount of information, so I will go relatively quickly. Hopefully, we'll be able to get to some questions at the end, and feel free, obviously, to chat those in, and we'll try and address them as they come. All right, so there's several different federal statutes that deal with fair housing. You have the Civil Rights Act of 1968, which has been amended. You have the Rehabilitation Act of 1973, the American Disabilities Act, the ADA, which people often talk about, and what's come into law a little bit, not into law, but what's come into focus a little bit more lately is the Air Carrier Access Act, which you may have heard recently with airlines prohibiting certain types of animals and things along those lines. So we'll briefly touch on all of these issues. Speaking of that Airline Act, there's some pictures in here that are meant to be kind of humorous. This is a individual who brought a potbelly pig onto the plane as an ESA. As she was trying to put her bags away, the pig was defecating all over the cabin, and then when she tried to tie it up to her seat, it began to howl. So ultimately, this individual was kicked off the plane. But again, people have been, one of the best things probably for associations is that people have been stretching these rules so much in different locations that it's causing politicians to take a look at this and crack down a little bit on some of these, what I think associations would consider fake support animals. So hopefully we'll keep seeing some trends in that direction. All right, so the federal statutes, 42 U.S.C. 3601, 3619, that's the original Fair Housing Act. As we talked about, you also have Title VII of the Civil Rights Act. It was amended in 1988. You have the amendment to the Fair Housing Act, which is the FHAA, 1988, which added a couple additional classes to what is considered a disability, including handicap and mental and physical disabilities and familial status. In Colorado, we have our own specific Civil Rights Act that also addresses discrimination. You can find that at CRS 24-34-501. All right. So what is it? What are these Fair Housing Acts? Ultimately, what we're talking about is discrimination against individuals that would prohibit them from being able to enjoy their home in the same manner that a non-protected individual would be able to enjoy their home. So there's different types of groups that can't be discriminated against. So you can't be discriminated against because of your race. You can't be discriminated because of family status, familial status. So perhaps you have you're single, or perhaps you have a wife or husband, or you might have multiple kids. All those things you can't be discriminated because of that. Same with marital status, creed, religion, national origin, sex, ancestry, handicap, disability, sexual orientation, etc. You'll see the ones that are bolded. Those are the ones that typically come up the most in the HOA context. So familial status, religion, handicap, disability. You could also throw in race. You get a fair amount of race ones as well. Then you can see the ones with the little parentheses. Those are the ones that are only state and do not apply to the federal. So different types of discrimination. So you have refusal to accommodate a protected person. That's kind of the most common that we see. Ultimately, someone in a protected class files a ARC. Maybe they need a wheelchair ramp. Maybe they want an emotional support animal, something along those lines, and the association fails to accommodate that person. You also have things such as discriminatory treatment. So this would be something in your rules or your declaration that discriminates on its face. Then you also have disparate impact. This is something that if you're looking at the rules or you are looking at your covenants and you were to read the rule or covenant and it appears on its face that it is neutral, it's not discriminatory, but it has a discriminatory impact on a certain subset of people, one of the protected classes. Again, you also have the refusal to allow modification to a protected person. So these are the ones that come up again the most for an association. An example of discriminatory treatment, we see it a lot in kind of a pool circumstance. So maybe you have a rule that says for adult only swim time. The laws have come out and courts have decided that this is something that discriminates against families. Ultimately, you are limiting the time that a family can use the pool. It's a much better practice to have, instead of adult swim time, you have either a 10-minute safety check time at the end of each hour. You see that a lot where everyone has to get out of the pool. You also have times where an association might say, instead of calling it adult swim time, it's lap time. So whether you're a child or whether you're an adult, if you're swimming laps, that's allowed. Otherwise, you got to be out of the pool. So we have different ways that we can still accommodate all of the people within the association, whether they are old, young, who want to play in the pool, or those who just want to use the pool for exercise. We can still allow those things, but we got to be careful on how we phrase the rules and that we're not discriminating against a certain protected class. So that's discriminatory treatment. That's where it's on its face, it's discriminatory. Disparate impact is going to be something that's facially neutral. So perhaps you have, and this came up in COVID a fair amount, you've adopted a rule that says noise has to be kept down in the common elements. Now, on its face, that seems to apply to everyone. It doesn't seem like that would be a big issue. However, most of the time, noise is an issue, especially on the common elements. It's because it's kids out there playing. And so that can be found to be a disparate impact where the rule itself is facially neutral, but how it's applied is we're only going to enforce it against those kids that were playing from 3 o'clock to 5 o'clock while I was still working from home, and that's all I can hear. You also sometimes see it maybe with bikes on might say no riding of bikes on the common elements. While again, that appears to be something that is neutral on its face, most of the people that are riding the bikes are going to be children, and so that rule can be seen to have a discriminatory impact on children and those with families. So again, how does this apply to homeowners associations? So when an HOA has a covenant or rule which prevents a homeowner from using and enjoying their home because of one of the listed protected areas, and the HOA refuses to make a reasonable accommodation or modification, that's what we're going to be dealing with. So ultimately, if you have this rule in place and an owner comes and says, doesn't have to be an owner, but if a resident comes and says, I need to have a modification, for whether a modification is going to be a physical change, so whether I need a ramp or something along those lines, or a handrail, or an accommodation being we have a no pet rule and I have an emotional support animal, I need to have it. These are the things that we need to look at. So if an owner requests that, we need to see, one, is the rule applicable? Does the owner meet the definition of disabled under the statutes? And if so, let's grant them that accommodation or modification. So if the association fails to fairly and consistently apply its governing documents to everyone, that's another way that we might be discriminating. So the selective enforcement can sometimes be brought up as discriminatory if the individual who is claiming to have been selectively enforced against is an individual of a protected class. So that comes up a fair amount as well. So we're going through our normal covenant enforcement process. The individual happens to be a minority or have a large family or something along those lines, and they claim that the reason that we're enforcing this rule is because of that. Sometimes we'll get in front of discriminatory courts because of that. When in fact, typically what's happening is we're enforcing the same rules against everyone. But if we aren't consistently applying those rules or governing documents to everyone, you run into that risk. So what requires an accommodation or modification? So you have the handicap, disability, familial status, religion. One of the things that comes up, hasn't come up so much in the last couple of years, but 3 to 5 years ago, it was a hot button issue, was group homes. People would be buying up a residential home in the neighborhood. They would maybe convert the garage and house 6 to 8 individuals in that. Sometimes it was a drug rehab facility. Sometimes it was an older person's home. But those are things that accommodations, modifications come into play a lot. So anytime a rule or covenant touches one of the protected groups, that's the time when an accommodation or modification may be needed. So what is a handicap or disability? So it's a physical or mental impairment which substantially limits one or more life activities, and it's major life activities. So caring for oneself, performing manual tasks, walking, seeing, hearing, breathing, learning or working. Eating is also under the ADA considered a major life activity, which makes sense. Now, if you have a record of such an impairment or are being regarded as having such an impairment, then you would meet that handicap disability. So one of the things to be aware of being regarded as having such an impairment, if an individual is in a wheelchair and they come to you and say, I need a modification to add a ramp, to ask for medical documentation that proves that they're handicapped when you see them in a wheelchair on a day in, day out basis, that probably is not going to be allowed. So it's one thing to think about when we're going through this. We'll dive into that a little bit more. But if you can physically see the disability, then we no longer get to request a letter that shows how the individual would qualify as disabled or handicapped. There's a vast range of what is considered handicapped or disability. So you could be orthopedic, hearing, mobility, speech and visual impairments, CP, autism, epilepsy, muscular dystrophy, MS, cancer, heart disease, diabetes, chronic alcoholism, chronic mental illness, AIDS-related complex, and mental retardation. We've also had allergies come up sometimes as handicap if the allergies are so severe that they would affect, again, a major life requirement of an owner or of a tenant. One thing that's important, though, is the range is limited by the fact that the disability must limit one or more major life activities. So the substantially limit is important. Just because it might have a minor effect on you might not reach the level of being handicapped or disabled. The law not only applies to the disabled person, but persons associated with them. So oftentimes we might be hearing from, it's a mother who's living with her daughter or son, and it's the son or daughter that is requesting the accommodation on behalf or modification on behalf of the disabled individual. Or it might be the mother or daughter. The mother is the caretaker of an adult child who is disabled. So there's lots of things that can come into play with who would be able to request the modification or accommodation and what we must do with it. It also applies to those recovering from substance abuse addictions, but not to current users. So while a group home that is there for drug addiction, for a rehab facility, that is something that would be protected. However, if the individuals there are currently using, that would not be something that would be protected by federal statute. So the ADA, we all deal with homeowners all the time, and oftentimes they say that the association is somehow violating the ADA, the Americans with Disability Act. Most of the time when they say this, they are incorrect. Typically, the ADA does not apply to associations, but we'll get into that a little bit. So the Americans with Disabilities Act of 1990, ADA, prohibits discrimination and ensures equal opportunity for persons with disabilities in employment, state and local government services, public accommodations, commercial facilities, and transportation. The ADA is codified at 42 USC 12101. The importance of public accommodations, that's what is going to be in the times where the ADA applies to an association, it's going to be because of that public accommodation provision. Again, most of the time, the ADA does not apply. ADA applies to places open to the public. Most homeowners associations are only open to its members. Anytime you think about renting to a non-member, or classes to non-members or offer classes to non-members that could bring in an ADA issue. So we most oftentimes see this in two places. Let's say three places. So if you're downtown and you have a high-rise community, oftentimes that first floor might be a commercial space. So in that commercial space, whether it's a restaurant or a store or something along those lines, because that commercial space is open to the public, the ADA is going to apply in that floor. Now, if you get up to the other floors, and those other floors are not open to the public, the ADA would not apply in that area. So in that high-rise setting, that first floor or that commercial space, that place of public, the public can get to, that would be a place where the ADA would apply. When you get to just the residential area, that's when you'd fall back into the FHA and not the ADA. Another time that we see this is pools. So we have some associations that might sell memberships to individuals that are not members of the association, or they might have a swim team that accepts members that don't live in the association. When you do these things, you run the risk that the ADA is going to apply to the pool. And in the pool situation, the ADA has specific requirements for pools. So it may require that you put in a handicapped chairlift, rails certain places, zero immersion. There are lots of, or zero entry, excuse me. There are lots of things that can come up in that setting where the ADA can be applicable. And so that is certainly an issue for you to remember. So the pools, you have downtown. The other place where ADA might come into is if you have a clubhouse and you rent that clubhouse space out to someone that is not a member of the association. Maybe you host weddings there or something along those lines. Now, as long as you're renting it out to a member, more than likely you're not going to be dealing with the ADA. However, if you rent it out to someone that's not a member, that could bring the ADA into it. And again, you have all sorts of ADA compliance issues if that's what the association is doing. So before you do anything like that, make sure you run it by your attorney. Make sure you tell them exactly what's going on so that they can look at it. They can look at your governing documents, make sure you have the proper insurance, make sure your building is up to code, things along those lines. All right, some of the types of discrimination. So familial discrimination. This is based on family status, the unequal treatment of children under 18, unequal treatment of pregnant women, unequal treatment of families based on size or content. So if you're discriminating against someone if you're discriminating against the children, that is always going to be a problem. If for some reason you're discriminating against pregnant women, or if your association for whatever reason doesn't like large families or doesn't like single individuals, all of those things, that is an issue that would rise to discrimination. So discrimination based on religion. So there's no duty to accommodate because this is not a handicap. There is a duty to treat all religions the same and remain neutral with all religions. So in Colorado, we had roughly maybe 5 years ago, we had an issue with some Jewish ornamentation that was put up in a condominium, and the individual was asked to take it down. That led to an actual law being passed here in Colorado that no longer allows you to discriminate against those kinds of things. But ultimately, if you're going to allow a cross to be up on someone's front door, then you have to allow other religious symbols to be up there, whether it's the Star of David or other things along those lines. Some of the examples that might come in, so if you had a rule that says clubhouse may not be used for any religious activities, that probably would be fine. However, if you allow a Christian book club to go in there and you're now denying a Jewish prayer group or something, that's going to be problematic. Same thing is that if you only permit holiday decorations that are Christmas lights, that's likely going to be discrimination, and possibly discrimination based on religion, because you're allowing one religion to do something but not other religions to do a similar action. Service animal versus emotional support animals. So another common misconception that comes up a lot, and Looks like we had one question here, so I'll try and answer this before we jump on too fast. So to clarify, if the HOA pool facilities facilitate swim meets and swim teams that may not be members in the association, it would then be required for the pool to be ADA compliant with stairs, chairlift. So the fact that you have a swim team, if you're hosting swim meets, there's an argument that it's now a place of public accommodation because you are having individuals that are not members of the association come in. With swim meets, I think you at least have a better argument that these are guests of the association. The bigger issue in my mind is if you have a swim team that you open up to people that are not just the membership. And in that case, these individuals are no longer guests. They are people that are coming here for a purpose. They're part of the team, but they aren't members. And so in the second issue, I think you would have to be ADA compliant with the stair and chairlift. In just the swim meets, I think it's questionable. The association certainly leaves itself open to an ADA challenge if that's what if they're hosting swim meets and they aren't ADA compliant. We have one other question. When a property owner uses the ADA for special treatment, my understanding is it's not for special treatment, but fair treatment like everyone else. Example, list of maintenance, they want to be pushed to the top of the list and claim ADA. So I'm not again, the ADA typically is not going to apply to an association. It's typically going to be the FHA. And it's not special treatment. It is accommodations or modifications that are needed for this individual to have the same access and standard of life that a able-bodied individual would be able to have. So sometimes when there is a known problem, whether it be we have an issue with a curb cutout that has to be there, and an owner moves in and there's no curb cutout, and so in order for the individual to access, they need the curb cutout. In that case, yes, that would probably move to the top of the list. So it's going to be fact specific. All right, we're going to keep moving on, and then I'll get back to some of these other questions. So service animal versus an emotional support animal. Again, neither of these, as you see, it's not service pet or emotional support pet. Neither of these are pets. So if there is an actual service animal or an ESA, they're not considered pet. So any rule that you have in your association regarding pets is not going to be applicable. ADA service animals are trained. The only type of a service animal is going to be a dog and or a miniature pony / horse. Those are the only two animals that can be a service animal. Service animals are allowed in restaurants and other public places. ESAs are generally not. An FHA emotional support animal does not need to be trained, does not need to be a dog or a miniature horse like the ADA. We have all sorts of interesting animals that have been ESAs. You have the potbelly pigs, you have ducks, turkeys, snakes, cats, dogs, chickens. All of these things have been said to be emotional support animals. Ultimately, the emotional support animal, all you really need is a letter from a doctor saying that this helps deal with your anxiety or deal with whatever it is that it's supposed to help you with. It's not a specifically trained animal. Again, we got a emotional support duck here. So in dealing with service animals or emotional support animals, the governing documents really don't matter if it's a service animal. Ultimately, service animals really aren't a problem. A true service animal is going to be an extremely well-trained, well-behaved animal. You're almost never going to have an issue with the service animal. Where we do see lots of issues is the ESAs, the emotional support animals. This animal may be regulated, but it's in very small ways that we can regulate it. So ultimately, same thing with a service animal. We can require that the owner either pay for or clean up after the animal. So that's something that is always going to be allowed. We may be able to limit where an ESA goes, not allow it on a pool deck because of sanitary reasons, health reasons. Service animal will more than likely still be able to be on the pool deck, but would not be allowed in the pool. So there's all sorts of things that we could get more fact specific about if you have actual issues. So what may be asked of the owner tenant? Under the ADA, so we have a couple questions. If an owner or tenant comes to you and says, I have a service animal. So if it is a service animal under the ADA, what we're allowed to ask is the dog a service animal required because of a disability? and what work or task has the dog been trained to perform. Typically, when you're dealing with an individual who has an actual service animal, they're going to have all this documentation for you right away. They'll provide it to you almost immediately. There's not really any delay. They know the drill. They're aware of it. They'll tell you what work or task the dog's been trained for. They'll let you know that they are disabled, and this is what the dog's required for. ESAs are a much more broad category. We are allowed to ask for reliable documentation of the disability, what accommodation they need, and how does this accommodation relate to their disability, or the nexus basically between the accommodation and the disability. So what is reliable? Doctor recommendation, medical records versus a note, other forms. So ultimately, a lot of associations, and it's a best policy to have a reasonable accommodation, reasonable modification policy, and have a form that these owners can fill out to help both the board and the owner get the information that's needed so that the association can actually look at this and make sure that the owner is entitled to this modification or accommodation. However, we aren't allowed to require a specific form to use. So if we have a form and it's a requested form that we'd like them to use, if the owner or tenant still provides us with all the information, but outside of that form, we still have to look at that and make a decision. We can't deny because they have not used the actual form. In terms of what is reliable, we cannot force medical records. We can accept medical records and review them if submitted, but we can't demand them. Reliable is simply going to mean if a owner submits a note from a doctor or a medical professional, doesn't have to be a doctor, it could be a nurse, could be a PA, it can be all sorts of different individuals, but if they submit a note from that individual, the association is likely going to have to rely on that. We aren't doctors. We don't have the ability to say, oh, you should go see a different doctor. This doctor doesn't seem like they know what they're talking about, something along those lines. That's not the association's job. The association's job is to look at the evidence that's been provided to them and then decide whether or not an accommodation or modification is needed. One important thing to remember for you guys as managers is you aren't the ones making this decision. You guys are information collectors. You get the information, you pass it on to the board. It's the board who is going to make the decision. And you need to stay on them because they need to make that decision in a timely manner. Pretty much any time, if there's nothing that you don't, if there's one thing that you get out of this more than anything else, anytime you're dealing with a reasonable accommodation or reasonable modification, you should get the information into the attorney. There is a lot of liability that comes with these, and there's a lot of timing that comes with these. And it is not uncommon for an association to be sued and payouts looking in the seven figures, high six figures, seven figures. We have cases that are $800,000 because an individual wasn't allowed to have their emotional support dog. You have cases in the millions for discrimination type actions. So these are serious issues. And although it might seem small, they carry with them pretty big damages. So I would be very cautious anytime you come across this and make sure you get it to the attorney so that the attorney can tell you, one, exactly what you can ask for, and two, help the board evaluate whatever information has come in and let them know, can we ask for more, can we not ask for more, etc. Oftentimes, as you guys all know, you ask for information and they'll provide you some internet document like this, where I registered them with an internet, and therefore this is a service dog. There is no national registry of service animals. So all you have to do here is fill in your own information that comes out. This letter does not provide us any reliable documentation. Now, if we get a letter from a doctor or a medical professional, that's obviously going to carry significant weight. This carries little to no weight at all. One caveat to the doctors, sometimes we do, another reason why you want to turn it into the attorneys is we are pretty well versed in the fact that there are certain online sites that you can just plug in and the doctor never actually sees you or the medical professional never sees you. They never actually talk to you. They just will say, yes, they'll basically fill out a form saying this individual should get a service animal or a support animal. On those, we can sometimes push back based on where the individual is, based on what has been said. It's not always the case, but depending on who the individual is that has provided this medical documentation, we sometimes have the ability to push back. So what types of enforcement actions are we seeing? So the most common enforcement action that we see is a CCRD action. CCRD is the Colorado Civil Rights Division. That is the most common one we see. Sometimes you'll see state or federal lawsuits. Again, potential outcomes. Look, if we lose one of these cases, especially a lawsuit versus a CCRD action, the damages can be extremely high. Oftentimes, you have in your insurance carve-outs for discrimination, and so if you're found guilty of discrimination, the insurance might not pay out. So it can be problematic. In terms of CCRD actions, we'll go through that whole process here in a little bit. But so pros and cons. What can the association really do? So the enforcer, the United States Department of Housing and Urban Development, HUD, they are the main enforcer of these civil rights issues. Their mission is to ensure the access to every American to a decent, safe, and sanitary home and suitable living environment. Now, from a state level, you have the Colorado Civil Rights Commission. They oversee the Colorado Civil Rights Division, the CCRD. Most times when you're talking to an attorney, what you'll hear in terms of statewide is going to be the CCRD. For the most part, HUD will push off any of these complaints to the CCRD and let CCRD do the initial investigation. The CCRD is the enforcement arm of the CCRC, and HUD has certified the CCRD as a substantially equivalent agency. So ultimately, the federal government pushes off a lot of this to the CCRD. In Colorado, you have the Baker case. We have a couple of big cases that have gone up to the Supreme Court. Our CCRD has been overzealous, maybe, or has felt that they have more power than the Supreme Court has ruled in the past. But we just have an aggressive CCRD. So that's another thing that you have to be aware of when we are fighting, when you're getting advice from the attorney about disabilities. We know that the CCRD tends to find disabilities or discrimination when maybe they shouldn't, but the cost to appeal that and then appeal it up to the Supreme Court of the United States and have them take it is obviously extremely high. So there is some balance that has to be taken place regarding this. Just another little picture of the miniature. It's supposed to be a play on the miniature pony, but that's a large dog. So what is the CCRD? CCRD is the government agency that enforces Colorado's anti-discrimination law. It works with the Equal Employment Opportunity Commission, the EEOC, and HUD. It investigates claims of alleged discrimination. The CCRD and the CCRC. They conduct hearings on character, causes, and extent of illegal discriminatory practice throughout Colorado. That's what the CCRC does. So ultimately, the CCRD kind of does the investigative approach, and then if it's not resolved from the CCRD, it then gets moved up to the CCRC. The CCRC also advises the governor and the General Assembly on policies investigated and dismissed by the division. Then you have the CCRD, who will adopt and amend rules for regulations in the enforcement of the state's discrimination statutes. So when you have typical process is homeowner has been complaining to the board, not getting any response. So the homeowner then goes and files a complaint with the CCRD alleging discrimination. With the CCRD, the formal complaints are filed free of charge. So that's a huge benefit and why we see so many CCRD complaints as opposed to actual lawsuits, because this is free to the individual who's complaining. So they submit it to the CCRD. The CCRD then takes it over. They will draft the actual charge and serve it on the respondent, which would be the association, the management company. Sometimes individual managers are also named. These are housing complaints. So the housing complaints must be filed 1 year from the date of the last occurrence of a discriminatory act. If it's not, then the CCRD will not investigate the claim. So the CCRD, again, I said, drafts the charge, so the charge of discrimination, and serves it on the respondent. The respondent is then given a chance to respond and provide information. So it's a very quick turnaround. You have 10 days from the date of the letter. So as soon as you get these CCRD complaints, you need to get it to your attorney. First thing we're going to do is reach out to the investigator. We know most of them because we deal with them a fair amount. So we're going to ask for an extension because there's a lot of documentation that we have to put together. Typically, we can get about a 2-week extension, sometimes 3 weeks, but it's usually about 2 weeks. So even with that, you're looking at roughly a total of 24 days to get all this information and the response done. It's a very quick turnaround. So the faster you can get it to us, the faster, the better the association is because we have more time to work on it. At the CCRD stage, dispute resolution is highly recommended. So one thing that we might do if we have gotten the documents from you and it looks like the association has more than likely unwillingly, but has discriminated, what we are going to recommend to the association is let's see if we can't have some type of mediation with the other side in the CCRD. Oftentimes, the CCRD will recommend that. The CCRD will reach out to the other side if that's something that we're proposing and see if they're willing to do it. If they are, we'll go have a mediation. This is not your typical mediation. In a typical mediation, you have a neutral mediator who really is there to try and just get the parties to come to a resolution that both of them can live with. When you're dealing with a CCRD mediation, the CCRD is the one who runs it. And they are very much geared towards the fact that they believe that discrimination has already taken place. So oftentimes they're going to build in specific requirements to any type of settlement that might require the board to attend an hour of classes, might have to adopt new policies, things along those lines. So it's not your typical mediation, but it is still a good way to try and get things resolved. After you filed if you don't do mediation, we'll file our response. The CCRD will conduct its investigation. Typically, this is going to be roughly a 6-month process. Sometimes they will ask for an extension, and we'll grant that extension. It might extend up to 9 months or so. The division director of the CCRD will make the determination. If the determination comes back against the association, so there's a finding of probable cause that the association did in fact discriminate, the next step is a conciliation. This is similar to a mediation, except in here, the terms are fully dictated to the association. Basically, the CCRD says, this is what you have to do. If the association chooses not to do that, we have the right to appeal, and we can take that to the CCRC, so that's Civil Rights Commission. And then we would take it in front of a panel and try and show that the CCRD was wrong in their determination. If we ever have to go to that route, one, it's very expensive. And two, it's difficult to show that the CCRD has done something wrong, which is why you see these cases getting all the way up to the Supreme Court. All right, so the request of information. So when we get the complaint, the charge from the CCRD, they send it to us. There's going to be a whole list of information that they need, and this is why we have to get that extension because it's a lot of things. We're going to have to provide them all the governing documents, typically all the resolutions. Any correspondence between this owner and the board or the manager. If there are other issues that are similar to this, that correspondence as well. Meeting minutes. Oftentimes we're going to want all the covenant violation logs. A lot of times these discrimination claims are, my house paint doesn't look that bad. They're only picking on me because I'm a Muslim or I am a woman or I am African American, whatever it is. And if we can show that, no, we sent out 150 paint violations over the last 3 years, that's a pretty good showing that we're treating this individual the same way that we treat anyone else. So the covenant violation logs are often very important. Homeowners lists, if we've had prior accommodation requests or discrimination claims, we'd have to disclose those. Oftentimes we'll need photos. Sometimes we'll need affidavits from the manager or the board. And so all this takes time, and there's not a lot of time in these cases. So again, 2 things. One, again, when you get these, get them over to the attorney as fast as possible. And then 2, make sure that you're informing the board of what's going on so this isn't caught by surprise when the attorney's like, we have to talk to the board as soon as possible to try and figure out exactly what's going on. So after we've submitted those documents, the CCRD makes its decision, either a finding of probable cause or a finding of no probable cause. So After the CCRD receives information, it can request additional information should that be necessary. Typically what happens in that, it's usually not physical information. Sometimes they will want to have an interview with someone from the board or the manager, so that can happen from time to time. After that happens, the CCRD will then issue the probable cause found or no probable cause found to show whether or not there was a violation or if there was a violation. If probable cause is found, the case proceeds to conciliation and the case is filed by the AG office. If no probable cause found, the complainant may still appeal to the CCRD or file the matter in state or federal court. So what's important here is even if the CCRD comes back and says, look, we didn't find any discrimination, the owner still has a right to file in state or federal court an actual lawsuit against it. I'm not going to lie, I think I've only seen once when the CCRD has come down with a decision saying there was no discrimination that took place that an owner actually filed the lawsuit. It's very rare. So the typical process is once the CCRD comes back and says there's no probable cause, the case is over. So some practice pointers. So evaluation of a reasonable accommodation request. Again, as managers, you are the individuals who collect the information. You're not the ones who are going to make a determination as to whether or not a reasonable accommodation request is reasonable or not. You might be able to provide some input, but ultimately it's the board that's going to make that decision. So when the board is looking at that, they're going to need to determine whether or not the individual has a disability, whether the requested accommodation is necessary to afford equal opportunity to use and enjoy the premises, and and whether the accommodation is reasonable. In terms of these issues, if the individual has a disability, again, if they are in a wheelchair, if you can actually see the disability or it's known, you don't get to ask for medical documentation. If the individual provides a note from a medical professional that says that this accommodation is necessary, that's probably all it's going to be there. The nexus is sometimes the hardest one. So if an owner is asking for something, a reasonable accommodation along the lines of, I have a walking disability, therefore I can't I can't mow my yard, I can't pull my weeds, I can't bring in my trash, something along those lines. I want an accommodation that says I don't have to do those things. That's probably not reasonable. The owner can pay for someone to do these things. We might have to work with them a little bit. We might have to give them a little extra time, but ultimately that's probably not a reasonable request. So all these are extremely fact specific. So again, you don't want to be the manager who's making that decision. The board doesn't know what's going on, and all of a sudden the board gets sued either with the CCRD or a federal or state lawsuit. That's why you provide the information, you get it to the board, get it to them fast, you let them know that this has to be decided on, and get them to act. You obviously want to be consistent in applications of policies. It's good to have that reasonable accommodation, reasonable modification policy for each of your associations. Now, there's one thing to, again, because those policies are written to be broad, the document might talk about anytime there is a reasonable accommodation request, we're going to ask for medical documentation. You still got to use your judgment. So if the owner is in a wheelchair and we know they're disabled, we don't want to ask that question. So you still have to use reasonable judgment even if you have that policy. You will also obviously want to document in writing all communications and decisions. We want to be sensitive to requests made by members of a protected class. We've gone over. And as managers, you want to be as educated as you can as to the fair housing requirements. Always want to have legal counsel review governing documents for discriminatory language and revise appropriately. Again, adopt a policy for all requests. Take a cooperative versus defensive stance with requests. So one of the big things that the CCRD is looking at is if we get a request in and the board doesn't think it's reasonable, the CCRD doesn't want the board to look at someone and just say no. So say they wanted to have an extra parking space or whatever it is, board doesn't find that reasonable. The board should come back with what they think is a reasonable option and submit that back. So if there's dialogue going back and forth, that's usually a pretty good indicator that the association is not being discriminatory. We'll keep going. So keep good records for all covenant violations, rule enforcement actions, and requests for architectural approval. Again, that is important. If someone is saying that you denied this because of my race or my creed, we want to be able to show that we're denying everyone for this. It doesn't matter that you were a protected class in this specific case because we've denied everyone that's asked for that. The applicant for a request is not required to be an owner or the person in need of the accommodation or modification. So again, you can ask on behalf of a third party. Doesn't have to be the individual who has the disability that's asking for that accommodation or modification. Again, don't request medical information if the disability is obvious, and it's obvious how the requested modification will contribute to use and enjoyment. Again, the healthcare provider is not required to be a doctor, a physician. It can be a nurse, it can be a PA, it can be a psychiatrist, it can be all sorts of different things. We want to respond to requests in writing in a timely manner. There have been numerous cases where a board has chosen not to respond, or they've asked for more information and not given a response, and 30 days go by, 60 days go by. Ultimately, what the courts have found is that that is constructive denial. You waiting to give a response is ultimately saying they don't get, it's a no, it's a denial. So these things have to move along pretty quickly. If we need additional information, we got to make sure we're following up and showing that that communication is there. If there is no request for a reasonable accommodation or modification, there's generally no obligation to make the accommodation. However, if a verbal request is made, follow through. Also, if an accommodation is obvious, you might want to offer it. So just like there's no magic language to ask for an accommodation or a modification, but if it is requested, we need to do something about it. Even if it's just done verbally. So if it's done verbally, the best practice is to respond back to them with an email saying, look, this is my understanding of what you're asking for. If this is the case, please provide us with X, Y, Z. Otherwise, we want it in writing and we can go through those same steps. But again, it's why it's great to have a policy in place. It just makes it easier for you and makes sure that the association is doing the same steps each and every time. Again, do not delay a request because of a related or unrelated violation at the time of request. So this one does come out a fair amount. A owner is a constant pain in the board's side. All of a sudden, they have some violations going on. All of a sudden, the owner comes back and says, look, I need a reasonable accommodation for X, Y, Z. And the board refuses to look at this until the owner comes into compliance for the other issues. Don't do that. That's a real quick way for the association to get liability and be sued. These are separate and distinct items. So if a person needs accommodation, they need accommodation. It doesn't matter that they're late on their dues or that they're violating something else. So be very mindful of that. You also want to place all violations on hold while the applicant obtains requested information or advise that fines will be removed if they are found to meet the animal per the FHA. So this comes up a lot where a no dog community, we send out a notice letter, then we send out a fine letter. Finally, the individual pops up and says, no, this is an ESA. We ask for information to prove that it is an actual ESA. We don't want to continue with the fine process during that stage until we've gotten all the documents. It can be seen as retaliatory if we do that. Applicants will generally not be liable for the cost of an approved accommodation. So with an accommodation, typically that's a change to a rule. Maybe it's a curb cutout, but for the most part, accommodations don't have a cost to them. So there's not going to be any kind of charge like that. The time that it might, so sometimes you'll have a rule that requires any pet to be DNA tested or a pet to be some other requirement that has a charge to it. Because these aren't pets, they're service animals or support animals, those charges are not subject. They're not subject to those charges. Now with a modification, for the most part, the owner is responsible, or the tenant, the person requesting the modification is responsible to pay for those modification fees. If we're going to deny something, again, you should have talked to your attorney, and the attorney should walk you through how to document that denial thoroughly so that we can show exactly why we denied it, what grounds the association had, etc. Remember that the law allows disabled persons to enjoy their homes to the same extent as those without disabilities. Be reasonable. Ultimately, be sympathetic, be reasonable. I know we get a little jaded in this industry because we feel like so many people, especially with support animals, are abusing the system. Bear in mind that the reason these laws are here is for those people that actually need them. And we want the laws to be easy for those who actually need it to be able to use them. We don't want them to have to jump through a bunch of hoops because they actually need it. So the flip side of that is that it is sometimes easy to abuse the situation. And oftentimes we don't know what's going on in someone's life. Maybe they don't have an outward disability. Maybe they don't have X, Y, Z. I mean, I just had a story. My family, my youngest child has a disability that you can't really see when he is around. He's a little 7-year-old, and so we have a disabled sticker. We parked at a restaurant. We parked at Chili's. We got out and got yelled at for 5 minutes by an individual saying, "Why are you parking in this handicapped spot? None of you are handicapped, blah, blah." The short story is we don't know what's going on in someone's life. We don't always understand what's happening. So have some type of empathy and try to come away from that jaded view that we all have that someone's just trying to beat the system. Because, again, we don't know what someone else is going on, what's going on in their life. Obviously, we want to make sure you guys are as educated as possible. That's why we have this class. Always review your governing documents. Always make sure your record keeping is good, especially when it comes to these covenant enforcement type matters. It's best and makes your job a lot easier if you have reasonable accommodation and modification policies and forms. Again, remember, they don't have to fill them out, but it's a good way to show what information you need and how an easy way for an owner or tenant to get it to you. So consequences, if you lose, high costs. I mean, it can be anywhere from $1 to $1 million or higher. If you win, you lose. So CCRD complaint is there. We get so used to the fact that we get to charge attorney fees back to an owner if we win. We don't get to do that in a CCRD action or discrimination action because it's seen as, it's been ruled to be retaliatory. So even though we win, we don't get to charge that back. So the association is going to have the cost of hiring and paying for the legal counsel. It's time and aggravation to get all those documents together. It can also be a public relations nightmare if they go to the news. I mean, HOAs already have a horrible reputation, and it's not uncommon for the news to completely get the facts wrong and put a very slanted view towards the association. So again, the CCRD is not the only way the FHA and FHAA can be enforced. Plaintiffs may go directly to the courts and bypass the CCRD. Because the FHA is a federal law, this case will be in federal court typically, unless they're going to go under the Colorado civil rights law, which is less common, but sometimes does happen. And when we're in federal court, it's extremely expensive for the association, extremely expensive. So we want to try and avoid these things as best we can. Some of the things that come up a lot, so there's just some quick ones, and I'll get to these questions. So oftentimes you have things about breed. Can we deny a breed of dog if it's a service animal? Short answer is no. We can't prohibit based on weight or breed. In that case, Florida was trying to do it. Florida Association, $100,000 was awarded. But you see a lot of times, for whatever reason, especially down in Colorado Springs, we have a bunch of weight restrictions on animals. Those do not apply to service animals or support animals. Another case, again, which breeds, the Texas and Florida, these counties prohibited pit bulls. Even though the county prohibits, the association can't. So ultimately, we can report it to the county that there's a pit bull, and they can do their own process, but we don't get to deny it based on the simple fact that it's a breed that's not allowed in the county. We don't enforce county rules. And the rules that are in the association's documents, if they deny a breed, that would not be applicable for FHA consideration. Again, we can require that owners clean up the service animal or emotional support animal waste. In Connecticut, there was a case, it was a mentally disabled defendant. The owner was not cleaning up the waste. The association was able to evict them for this reason. It's a long process. There's got to be a lot of documentation, but we do have that ability. Leashing laws. So owners not allowed to bring service animal in common areas. Owner sold their unit, then sued the association. Court ruled that the association could not prohibit service animals from the common areas. So this was a case where the individual wanted to bring the dog onto the common area. They had a rule that no dogs in the common elements. Because this was a service animal, the court ruled that they should have been allowed to be able to bring it in there. It's also similar to like a pool deck case. Those things happen from time to time as well. Delaying granting accommodation. Again, we talked about this briefly, but if you wait too long, it's deemed a constructive denial of the request, and that's just as if you never responded. So we have to make these things go fast. Really, if you get past 30 days, you're probably in trouble. Lots of things talking about the nexus and the disability. Again, if the owner has a note from a medical professional stating that the animal helps with anxiety and the disability. So in this case, if they have a homeowner that has an animal, helps with anxiety, and the disability is multiple sclerosis, then it might not be allowed. If the disability is PTSD, then the animal would be allowed. So there has to be a nexus between what the disability is. So in this case, they're saying the disability is multiple sclerosis, but the dog only helps with anxiety. We we don't have anything that shows that the owner is suffering from anxiety, that would be grounds to deny it. But again, you want to get these in front of your attorney because they're all fact specific. Talked about specialized training in terms of the support or the service animals. Emotional support animals don't have any specialized training. They really are just there to provide emotional support. They're comfort animals. All right, let's get to some of these answers to some of these questions since we only have about 5 minutes. Let me go back to the top here. For ESA, is there a difference between a short-term and a long-term condo rental? The short answer is no. Whether it's short-term or long-term, it doesn't matter. If an individual needs an ESA, the individual is entitled to have an ESA. One thing that I will say is that a disability has to be permanent. So if the individual broke their leg, that does not entitle them to a reasonable accommodation or a reasonable modification. It has to be a permanent disability. If your HOA allows the owner to lease rent their unit, then are we required to provide ADA pool lists regardless of the number of tenants in the community? So no. So under the owner who's leasing or renting their unit, those individuals, and your governing documents are going to talk about this too, but they have all the same rights as an owner, and that's not the general public. So they're going to be a guest or an invitee of the owner who's leasing it to them. So that would not open the association up to ADA requirements. It's when we open up the association to anyone and everyone. So in this case, anyone can join when we've opened it up to non-members, the swim team, anyone can join it. Or we've opened it up to 4 other associations that can join. Like that is opening it up to the general public. Familial unequal treatment of families based on content? ? So I'm not exactly sure what this question is. In general, based on content, I mean, if you have a rule that says, again, we'll go back to swimming rules. If you have a rule that says no one under 8 is allowed in the pool without adult supervision, that probably is going, let's say 12. No one under the age of 12 is going to be allowed in the pool without an adult present. That can be unequal treatment because you could have a 11-year-old or a 12-year-old that's a highly decorated swimmer and doesn't need it. The real issue with that is that when they're younger than 12, when they're 8 years old, when they're 9 years old, maybe it's a safety issue. But if they can show, and oftentimes what we'll say in the rule is that if you provide us with documentation showing that you are a qualified swimmer, et cetera, then that rule is not going to apply. We can do something along those lines. But ultimately, if you're able to use the facility safely, then you should be able to use it regardless of your age. The same way that appropriate swim attire. So if you say no swim diapers, that can be discriminatory both of young people and old people. Or there's all sorts of different things that are an issue. You got to be careful with those pool rules. We got to make sure that, again, pool rules should always be reviewed by the attorney because those are some of the easiest ones to be discriminatory because we think that we are trying to deal with behavior. So oftentimes we want adult supervision because kids are loud, they're running, they're doing all these things, and we want someone to control them. That's where we get into discrimination type claims. If we're doing it based on safety, that is a more reasonable ground, and we might be able to get away with it. In a single-family home community, if a property owner chooses to rent their property, do we have to honor ADA and common elements? Again, ADA typically is not going to be applicable to associations. Renting is not going to have an effect as to whether the place becomes a public accommodation or not in terms of renting someone's unit. So hopefully that answers your question, but it's not going to, if someone rents us a single home family or a condo, they rent their condo, that neither one of those things open us up to public accommodation. Does this mean an adult over 18 cannot be required to accompany a child under 18 without the pool? Yes. If your age limit is 18, that is certainly not going. That rule is going to be discriminatory. The CCRD has given us some language that there is a certain threshold of an age. Usually, it's going to be in the single digits as to when you would need to have a person who is there with them for safety purposes. But a 17-year-old or a 16-year-old or a 15-year-old, they're all perfectly capable of typically swimming and doing those actions. So ultimately, we want those rules to be tied to safety. that rule that we just read, does this mean an adult over 18 cannot be required to accompany a child under 18? Typically, that rule is really to address behavior, not to address safety. If there's a path on association property that links to a public walking path, does it need to be ADA, since others may use it to cross the property to get to another property on the other side? With signage fixed that says private property. So, I mean, it's fairly specific. A sign would be good to have up there. It says it's private property, so that we're not opening it to public access. I'm not sure what type of ADA requirements would be on the walking path. I mean, really, it's a sidewalk. So, I mean, I would want to see signs. I mean, you'd want to talk to your association's attorney to get facts, but I think there's probably not a whole lot you'd have to do other than just to put private property up. How do zoning laws apply for an ESA? For example, most municipalities do not allow farm animals, blah, blah, blah. Again, we don't enforce zoning laws. The county does, or the city does, municipality. We only enforce what's in our governing documents. And our governing documents is what we have to base the accommodation or modification on. So the short answer is if our documents say you're not allowed to have a farm animal in it, we're going to have to grant that accommodation. That's just how it is. We might be able to turn to the city and they might be able to enforce it, but from the association standpoint, if we have the doctors know they met all the other things, we're going to have to allow that, even though it might be a non-typical animal, whether that be a pig or a chicken or a duck, etc. Can you require the doctor note be within a certain time frame? Example, written in the last 30 days. So again, we aren't talking about temporary disabilities. So if the doctor's note says that this is a disability that is temporary, it doesn't matter when it was written. That's going to be something that we could deny on. If the note says that it's a permanent disability, then no, there's no time frame on it. There is some discussion that because it has to be permanent, that you could request additional information on a yearly basis. I wouldn't recommend doing that, but it is something you could discuss with your attorney. The HOA governing document states that the homeowners can only own 2 cars and that both cars need to be parked in the garage. Homeowner's wife died. As a result, his daughter, her husband, and their daughter moved in. They now have 3 cars and are claiming they should be allowed to own 3 cars and they should be allowed to park one of their cars in visitor parking indefinitely. They've lived with the father for more than 2 years now. So they claim disability. The homeowner has it that he is depressed and high blood pressure. Does FHA protect this situation? So, I mean, again, it's extremely specific, and you'd want to not take any of this for granted. In general, I mean, we're going to have to look at what the documents are. I'm not sure how any of this disability would relate back to the father, and why that would require them to need extra cars. So based on just what you're saying, I think that probably does not. But you need to get all this information in front of the attorney so that they can look at it. Would verifying a letter submitted to the management office with the practitioner who completed the accommodation request on behalf of the resident be appropriate, along with verifying the license number of the submitting practitioner? With verifying a letter submitted to the management office with the practitioner. I mean, so again, we can only ask her. We can try and verify, and if the person is not an actual medical professional, that would be something that we'd want to consider. But we don't get to dictate what doctors they go see or who they go see, or get to, short of having some type of additional information that would show that they never actually went to the doctor or something along those lines. We would not be able to more than likely ask more questions than what those 3 original questions were. Homeowner rents clubhouse. Is HOA required to provide reasonable accommodation for non-owner guests? So the short answer is probably yes. If there is a need for reasonable accommodations for this specific time, and it probably would be a reasonable modification, I'm guessing, more than an accommodation. But maybe it would be an accommodation in terms of a no pet rule and they need to be able to bring their ESA in or something along that line. But more than likely, yes, the association is still going to have to abide by the FHA. All right, last question. Still confused on condos, short-term rentals, and ESAs because it's a transient guest. It seems that hotels definitely don't fall under FHA. So why is a condo different? So if you are saying short-term rentals, does an ESA, I don't know why an ESA would not. So, I mean, the short answer, Kyle, is if you were to If you want to shoot us an email with what the actual facts are, we can go and look into it. But my understanding is that it would still be required. Although you say it's a transient guest, in Colorado, short-term rentals are not deemed to be commercial. They are deemed to have the same effect as any other residential use. So I believe the FHA would apply. But if you have a specific question, you can go ahead and email it to me, and I'll try and take a look at it for you. Everyone, appreciate your time. Sorry we were 5 minutes over. I tried to go as fast as I could, but thank you very much. You guys have a great afternoon, and feel free to reach out with any types of questions. Take care, everybody.